A torturous and ungodly jumble? I mean, wow. That's how Oliver Cromwell described English property law centuries ago. And honestly, while things have gotten a lot better, figuring out who really owns what can still feel like trying to untangle a very old, very complicated knot. So, how did we get from that jumble to the system we have today? Let's dive in.
Okay, so picture this. You've done it. You just bought your dream home, Green Gables. You get the keys, you walk through the front door, and you find you're not alone. There's a guy named Stanley living there. He says he's the seller's brother, and oh, by the way, he paid for half the house years ago. And then, before you can even process that, your new neighbor, Henry, pops over to say he has a 5-year lease on your paddock and a right to walk his dog through your garden whenever he wants. So wait a minute. You have the deed. Your name is on all the paperwork. You own the house, right? But what does that actually mean? Are you now Stanley's landlord? Is Henry's pony about to become a permanent fixture in your field? This right here is the absolute core question of property law. What rights and obligations are so sticky they travel with the land when it's sold?
To figure out the answer for today, we've got to jump in a time machine and look at the past. Because the old system, it was like a jigsaw puzzle with 1,000 pieces and no picture on the box. It was this messy, uncertain game where the number one rule often felt like you had to be a mind reader. This whole concept of owning land has been a work in progress for almost 1,000 years. It all started back in 1066 when the king basically owned everything and everyone else just held land for him. It took centuries to chip away at that, but the real earthquake was in 1925. That's when a massive effort was made to finally simplify that ungodly jumble, a process that was tweaked and modernized again in 2002 with the law we use today. So, historically, the law tried to make sense of this by splitting rights into two big buckets. You had legal rights, like a formal mortgage. Think of those as superglue. They stuck to the land, and every single future owner was bound by them, no questions asked. But then you had equitable rights, like Stanley's financial claim, and these were a lot squishier. Whether they stuck to the land depended on a much fuzzier test. And that fuzzy test was called the doctrine of notice. It basically said that you, the buyer, were stuck with any equitable right you had notice of. But, and this is a huge but, notice didn't just mean what you were actually told about. It also included anything you should have found out if you'd asked the right questions or given the property a good look over. You can see how this created a total minefield of uncertainty for anyone trying to buy a house. To get out of one of these hidden traps, a buyer had to prove they were this almost mythical creature, a bona fide purchaser for value without notice. I mean, just look at this checklist. You had to act in good faith, pay actual money for the place, buy the proper legal title, and, the real kicker, have absolutely no notice whatsoever of the hidden right. The burden on the buyer was just massive. Clearly, this confusing system couldn't go on forever, so in 1925, Parliament stepped in with a really revolutionary idea. The goal was to drag property law into the modern age, to move away from all this mind reading and guesswork and towards a simple, reliable public record, a register. And the fundamental shift in thinking was so simple, but so powerful. The law just flipped the script. Instead of forcing every buyer to be a detective, the responsibility was now put on the people claiming these hidden rights. If you have a right, it's now your job to protect it by putting it on a public register. If you don't, you risk losing it completely when the property is sold. Now, this revolution created two parallel systems for property that still exist today. There's the older system of unregistered land and the modern system of registered land, where the title itself is officially recorded in a central database. And both of these systems rely on the principle of registration. In the old, unregistered world, you register your claim against the owner's name. But the modern, registered system, it goes way further. It puts the entire title deed online, on a central register, which is meant to be the one, single, definitive source of truth for that piece of land. And that modern system has pretty much taken over. Today, more than 85% of land in England and Wales is in the registered system. So, naturally, that's where we're going to focus for the rest of this. Okay, so this modern registered land system is built on three really powerful principles. Think of them as the three pillars holding the whole thing up, all designed to make buying property simple, safe, and secure. First up, you've got the mirror principle. And it's pretty much what it sounds like. The idea is that the register should be a perfect mirror of reality.
It should accurately and completely show you all the rights and all the burdens affecting that piece of land. In theory, what you see on the register is what you get. Simple as that. Next is the curtain principle. This one is all about making a buyer's life easier. It says that all the complicated ownership drama, like who actually benefits financially from the property, think of Stanley's claim, is kept behind a curtain. As a buyer, you only need to worry about the legal owners listed on the title. You don't have to investigate the family soap opera going on behind it. And finally, the insurance principle. This is the ultimate safety net. The state actually guarantees that the register is accurate. So if it turns out the mirror was wrong and you lose out because of a mistake on the register, the government compensates you. This builds a huge amount of trust and confidence in the entire system. So, a perfect mirror, a protective curtain, and a government guarantee. It all sounds completely foolproof, right? A system of total certainty. Well, almost. The system itself admits that the mirror can't be perfect. There's a known flaw, a crack. And this crack is called interests that override. These are a special list of rights that are considered so important that they will bind a buyer even if they are nowhere to be found on the register. And the biggest, most significant one of all, the one that causes the most debate, is the rights of a person who is in actual occupation of the land. All right, armed with these modern rules, let's head back to Green Gables and finally solve this puzzle for our poor buyer, Anne. So how does this all shake out for Anne? Let's break it down. First, Stanley. His claim for contributing money is a beneficial interest. Normally, that's behind the curtain. But because he was physically living there, his right might have jumped out from behind the curtain to become an overriding interest. The whole case for him hinges on that one question. Was he in actual occupation? Now, Henry's claims. His 5-year lease, well, short leases are a classic overriding interest. They bind the new owner automatically, so Anne is definitely stuck with that one. But his right-of-way to cross the garden? That's more complicated. If it was a formal legal right that was obvious just from looking at the property, it might override. But if it was just some informal agreement, he really should have protected it on the register. If he didn't, Anne is probably in the clear. So here it is, the big takeaway. The land register is an incredible tool. It took that ungodly jumble and turned it into a system that, for the most part, makes sense. But, and this is the critical but, because of that crack in the mirror, because of overriding interests, it doesn't replace the need for good old-fashioned common sense. You still have to inspect the property carefully and see with your own eyes who is actually there. And this leaves us with a final, fascinating question. The whole system is designed for clarity, for commerce, for making land easy to buy and sell. But in that quest for a perfect mirror, does it sometimes risk overlooking the complicated, messy, human reality of the people who actually call that land home? That's the fundamental tension that still sits right at the very heart of modern property law.